So, how much should you compensate Tom? First of all, if there are stipulations in the agreement with Tom, you should comply with that. Second, if there are no such agreements, you should abide by laws. Then, what do the laws tell us? Let's review the outlines of contract remedy rules. If you are not in trouble, grasping outlines would be enough for now. If involved in trouble, please consult lawyers. Though there could be various options, two major remedies for contract breach are specific performances and monetary damages. Specific performance means delivering properties to the other. Though it seems simple and beneficial for the buyer, this remedy is limited in many countries to the cases where monetary remedies are inadequate. Typical cases are sales of lands or unique goods such as antiques. Mainstream is the monetary compensation. Basic ideas can be divided into two. First, expectation damages. It means putting Tom where he has been in, had the contract been performed. Second, reliance damages. It means putting Tom where he has been in, had the contract never been formed. Consequential damages are one form of expectation damages. It consists of general damages and special damages. General damages are damages a reasonable person could have foreseen at the time of the contract formation. Special damages are damages resulting from special circumstances. If such special occasions existed at the time of the contract, and both parties were aware of it, special damages could be compensated. These are the first few steps of the damage compensation concepts. Then, how much should you pay for Tom? If you had to compensate such $2,000, it could have changed your decisions. For these sale of goods cases, there are some codes in the US, which stipulate the consequential damages. But the basic ideas are the same as what we discussed. So, if we assume that Tom's reselling the phone to John at $2,000 was a special circumstance, how much you should compensate would depend on whether you had reason to know it at the time of agreement with Tom. As you see, this is the facts evaluation problem. If the trouble goes to official proceedings such as arbitrations or lawsuits, evaluations should be made by arbitrators, judges, or juries. Predicting such results in a precise way is difficult, because the decisions rely on human evaluations. That's why you should consult lawyers in case of trouble. So, what is our conclusion today? Which is the better action in the end? In conclusion, there seem to be no absolute answers in this case. If you chose to sell the phone to Tom, that would be okay. You must be a nice person. If you sell it to Jerry, that would be okay too. But requirements for this option would be this. You could cancel the contract amicably with Tom. Or, you could predict damages precisely, and such damages would not exceed your expected profits. If these calculations are too difficult, going back to the basics could be your option, which means just keeping promises. I hope you enjoy this video. Please do not forget to subscribe. See you soon.